right? The question is, has the state proven each and every element? And as long as they haven't proved one element, they therefore necessarily haven't proved every element, right? If they haven't proved one element, they haven't proved every element. So it's like, okay, have they failed to prove even one element? It's like, yes. Okay, which element have they failed to prove on civil? Actus reus. What do you mean? Well, she has to have hit him with the car. Okay, how have they failed to prove that? Well, how does she go backwards in a 7,000-pound car, 25 miles an hour, with enough force to create some sort of disabling injury? How does she do that and also simultaneously not cause any torn ligaments, broken bones, or even bruising? How is both those things possible at the same time? That doesn't make sense to me. At least, and that would fall into the category of reasonable doubt. Now, there might be some answer to that question of how it's possible, but of course, they have to prove beyond a reasonable doubt, right? So, if you come to me and be like, "Well, actually, here's how that could happen medically," I'm like, "Well, even assuming you could provide some sort of possible scenario," I'm like, "It still is implausible, and you do have to convince me beyond a reasonable doubt." So, how are you doing that? How are you getting to beyond a reasonable doubt certainty that the car did all those things? And I'm like, I don't know how you're going to do that. That seems very implausible to me. So, now if the state can somehow convince me of that element beyond a reasonable doubt, then we'll move on to other things because there are other problems in the case. But for me at the moment, that's the easiest way to resolve it. Right. And then I literally don't have to ask any other questions because it is dispositive, as we say in law. It literally disposes of the case. Because of that one thing, I can literally stop asking questions and my life becomes simpler, right? Because having failed to prove one element, I don't have to then move on to, well, what about all the other elements, right? What about all the other evidence, Kurt? Right? What about all the other elements and what about all the other evidence? I'm like, I literally don't have to do any of those things because if she didn't hit him, it literally disposes of the case. It is dispositive. And then we all get to go home. It's great, right? It's fantastic. And therefore we make our lives simpler. Simplifying my life is a good thing. Yeah. And then people sometimes ask me, okay, like what do you think happened? I don't know. See, this is the other great thing about clarifying questions. What do you think happened? Don't know. Who do you think the Alberts did it? I don't know. Do you think Chloe did it? Do you think he was beaten up in the house? I don't know. Do you think he was dragged by the Alberts, onto the lawn? I don't know. I don't know. Right? And it's like I don't need to know any of these things. It's fantastic, right? I could just literally stop asking questions and move on with my life. Isn't it possible she did it? I guess. Isn't she getting away with murder? Maybe. But that isn't the question. The question isn't, did she do it? It's literally not the question. The question isn't, did she do it? That is literally not the question. The question is, has the state proven it beyond a reasonable doubt as to each and every element? That is the question. Keeping our eye focused on the question makes our lives simpler. Keep our eye focused on the ball, people. Keep our eye focused on the ball. Right? Now, as to juries, I don't. Experience has told us that unfortunately juries are not the logicians we would all hope they are. That their ability to do what I just said leaves a little bit to be desired. Juries seem to act more on feels and what would be the right word? They act more on impressions and act more on zeitgeist than logical facts. It's one of the reasons that engineers don't make it onto juries because the engineers might actually think about things in a logical way with logic and reason. Yeah. Sentiment, yeah. Emotion, yeah. I think here's sort of the best. Here's the with the jury. If the prosecution plays its cards right and they organized things right. They started with I hit him, I hit him, I hit him, and they brought what 3 or 4 or 5 witnesses who say that she said that. So they've got that. Now you can disbelieve that that was said, and you could, and even more to the point, you could believe that even if she said it, she said it in a state of hysteria, and it shouldn't be credited. But juries eat confessions up, and I'm just telling you they do, and you have to accept my word for it that juries eat confessions up. Doesn't mean they do it every single time, but God, man, confessions, yeah. So they have the I hit him, I hit him, I hit him. That's how they started. If their ARCA thing goes really well, they can sort of close with ARCA and the physics and, all that. And then everything else sort of becomes noise. Primacy and recency, as we would say in trial advocacy, right? They started with the I hit him, they started with the confession, we'll call it. That was their primacy. Their recency, which we haven't gotten to because we're talking about what will be like the last thing out of their mouth, presumably in their rebuttal case. Presumably the last thing out of their mouth is probably aperture. If I were them, I would seriously consider not even calling aperture in my case in chief. I would seriously consider not calling aperture in my case in chief and calling them in my rebuttal case. I don't know if I do it, but I think about it. Because that way and let's assume that aperture does what they need to do. Let's assume aperture, comes off convincing and persuades everyone that, or it persuades the jury that, the physics allow for this. So their primacy therefore becomes I did it. Their recency becomes aperture. Everything else becomes noise. And they're along, and they're with a little bit of skill in their closing argument, they're a long way towards home, I think, is the sad reality of the situation. Then you throw in the fact that, there's a defendant sitting at the defense table that automatically gives the prosecution 5 to 10% automatically. So their odds of winning start at 5 to 10%. There's a defendant sitting at the defense table that gives them 5 to 10%, bare minimum. And then you throw in the fact that it's a dead police officer. That's gotta up that base percentage, in a non-consequential way. That's gotta make it maybe a base 15 or base 20% chance of winning, because there's a dead police officer, don't you know? And if Karen Read comes off as unlikable, which I think, to be fair, I think she can, to many people, come off as unlikable. If she comes off as unlikable, and a drunk, which, she probably had a lot to drink that night. Not that everyone else didn't, but she's the one on trial. If she comes off as unlikable and a drunk and jealous and all the rest of it, you throw in the Aruba stuff, you throw in the motive, I figure 60% is a reasonable probability. Vibes, by the way, was the word I was looking for earlier. I couldn't quite get there. Juries work on vibes. Vibes was the word I was looking for, now that my brain finally caught up. Yep. And then, of course, Proctor is going to come on the stand at some point, would assume. I figure there's like a 90% chance the defense calls Proctor. I just can't see the downside of calling Proctor. I can't really see the downside of calling Proctor. Every answer he gives me is equally good. He admits to it on the stand, it's good. He doesn't admit to it on the stand, it's good. Right. Either he tells me the truth, or he's evasive, and either way I win. So I figure there's a 90% chance the defense calls Proctor. And, depending on how that goes, I still think on balance, although I think other attorneys would very much disagree with me on this point. I think that there are a lot of attorneys who would very much disagree with me. I think on balance, the prosecution probably should still call Proctor for their own sake. It's not a fun position to be in as the prosecutor. You don't want to do it. You can make your case without him. You don't need him to make your case. You can make your case legally without him. The problem is, if the defense calls him, they're going to make it as painful as possible. And they were going to do that already. But if you call him first, you can get out ahead of it and you can control it a lot more. And you can't do that if you don't call him first. So and also by calling him first, you also, you know, build some credibility in front of the jury. And credibility in front of the jury is a huge factor, So it is not a fun position to be in as the prosecutor to call Proctor. But I think on balance, although I think other lawyers would very much disagree with me, perhaps strenuously, to be honest, I think on balance, the wise move here is to call Proctor. You know, you call him to the stand, you ask him all the questions the defense is going to do, but you ask it more softly because you can control the tone of it, right? You ask all the questions the defense is going to ask, but you ask them more softly so it doesn't hurt quite as bad. The defense doesn't really have anywhere to go. I mean, they're going to ask him the same questions anyway, but they're not going to reveal anything new. So it's not as shocking. It's called drawing the sting, is the expression that lawyers use. It's like when you have bad facts, getting in front of bad facts is usually a wise course of action. Or it's a depending on the situation, but yeah, when you have really bad facts, getting in front of it is often a viable strategy, and I feel like is the strategy here. I figure it's the play. I guess Brennan must feel like there's not enough in it to justify it. He must feel like, and also by forcing the defense to do it, it gets sandwiched in the middle of the case. So he's really going for that primacy recency thing, right? By having the defense call Proctor, he gets a rebuttal case. So he gets to sandwich Proctor somewhere in the defense case. And he thinks that, there's not enough in it to justify calling him, and he thinks that he can fix what he needs to fix on his cross-examination. That feels like a lot, but that must be what he's thinking. And maybe he's right. Maybe he's right about it, but I still think on balance it's probably a mistake. But it's a tactical call. It's literally tactics. And it's like, okay. So, maybe this is the play. This is the one they're going to decide to run. But I think that it's worth a 5% discount at least. I would have said 2 out of 3, 66% to convict. And now I'm going to say 60% because I think it's an error. And if Proctor, really self-destructs or something, which seems plausible, can Brennan really rehabilitate him? I don't know, man. I don't know. We'll see. Yeah, I mean, fallen hero, you're right. It's bad if you do and you bad if you don't. Yeah, this is 100% true. It's just which poison do you like best? That's 100% right. You're damned if you do and you're damned if you don't. Proctor is a massive liability, and you can't make the liability disappear. The only thing you can do really is how do you control the liability. So yeah, it's which poison do you like? Which poison is best poison? And yeah,